Hello and welcome to the Ken Vercammen Law Office Legal Podcast. This edition, we're looking at restraining orders, and in this particular case, the New Jersey court found that calls by someone out of state to a New Jersey person who was in an assisted living was sufficient context for jurisdiction for a domestic violence restraining order and for possibly violating the restraining order. The name of the case, and they have to use initials in the domestic violence cases, SS versus LL. So here the defendant appealed from the entry of a restraining order in favor of the plaintiff. The facts are here. At the time of the entry of the final restraining order, plaintiff was an 89-year-old person, defendant was 78. The plaintiff suffered from mobility issues and required a walker or wheelchair, while the defendant enjoyed good health and remained physically active. The parties had been in a relationship 2 years before deciding to live together in plaintiff's home in Florida. However, the plaintiff then, at that point, evicted the defendant from her home after 1 month due to defendant's verbal abuse. Although the defendant resided with plaintiff again following a hurricane, their relationship continued to deteriorate until 2019, when plaintiff's daughter flew to Florida to help plaintiff move to New Jersey due to the defendant's continuing abusive conduct and refusal to vacate plaintiff's residence despite owning his own unit in the same condo complex. So upon arriving in New Jersey, the plaintiff here applied for a restraining order. The trial court granted the temporary restraining order, which gave exclusive possession of a residence in Florida, and basically said, no further contacts. At the hearing, the plaintiff's daughter informed the trial court that the defendant had violated the temporary restraining order by attempting to contact plaintiff at her independent living facility in New Jersey. After the defendant retained counsel, he made a motion to dismiss the case for lack of personal jurisdiction. The plaintiff argued the trial court could exercise personal jurisdiction due to the defendant's contacts with New Jersey following the initial temporary restraining order. The trial court there denied the defendant's motion and agreed they did have jurisdiction, and found and entered a final restraining order, finding that the defendant committed harassment, contempt by intentionally violating the temporary restraining order by calling plaintiff's living facility. The defendant then appealed, making the same arguments, alleging the conduct occurred in Florida. The appellate court, though, rejected the defendant's argument and affirmed the entry of the final restraining order, holding that the defendant's calling of plaintiff's living facility provided sufficient context for personal jurisdiction. And the name of the case is SS versus LL. Interestingly, if this guy didn't call the facility after the temporary restraining order, then the court probably would have found no, there's not, because all the actions previously took place in the state of Florida. For more information on restraining orders, visit website njlaws.com, and for representation in restraining order cases and criminal cases, contact Ken Vercammen's office in Edison at 732-572-0500.